Digital anchor Andre Asher, Michigan Chronicle, following the big news of the day, the Supreme Court decision to rule against affirmative action being used in college admissions, and it is impacting colleges and universities across the country, and get local reaction from universities here across the metro area and the state of Michigan. We're joined now by Jelani Jackson-Exum. She is the Dean of the University of Detroit Mercy School of Law. She joins us right now. Jackson-Exum, what was your initial first reaction to this ruling?
Well, I have to say that I definitely feel disappointed by the ruling, but not surprised at all. Those of us who have been tracking the direction of the Supreme Court pretty much expected that this would be the ruling, and behind the scenes, legal educators, those of us who lead law schools, as well as those of us who just work on issues of racial equity in education, have been preparing ourselves for this decision. But nonetheless, actually seeing it in the headlines was very disappointing.
So we know that Supreme Court Justice Ketanji Brown Jackson issued a dissent in the case involving the University of North Carolina. What was your take on her dissent?
It's a brilliant dissent, quite frankly. Out of the 200 plus pages of the Supreme Court opinion, in my opinion, you can cut straight to the dissent and you will learn all that you need to know about the importance of affirmative action, about the fight against it, and the push ahead. What Justice Jackson said in just a truly brilliant way was that the Supreme Court's decision is really divorced from what we know about the truth of the way race plays out in society. There's a many lines that I could point to that I think are really just gems, but in particular, she says, just because, I'm paraphrasing, but even if the law deems race irrelevant, we know that life does not, right? So that's not the truth of life. And I think that's so important. That's what schools will have to continue to face in making sure that we are able, within the bounds of the law set by the Supreme Court, to continue to recruit diverse classes, to continue to uplift our students of all backgrounds, to continue to promote the idea, the truth that having diverse classes, learning from one another, building institutions of equity and places of belonging is so valuable to education that we will have to work on the ground about the realities of the law, the realities of life, I should say, despite what the Supreme Court has now declared as the law.
Basically, the court is saying this is unconstitutional. What's your perspective from the legal angle that they've taken on this ruling?
Okay, so the Supreme Court was basically interpreting the 14th Amendment Equal Protection Clause and is reading that language in a colorblind fashion. So this is something that's been fought for many years, for decades, with people on both sides of the political spectrum, of the legal analysis spectrum, on whether the Constitution is colorblind or whether it should be one that is recognizing race and working toward equity in race. And so the Supreme Court today decided to take a colorblind approach, basically saying that you cannot use race at all in many instances. This was a narrow opinion about college and university admissions specifically, but saying that because of the colorblind reading of the Constitution, colleges and universities cannot use race in college admissions. This is really, in my view, sort of turning the clock back on a lot of progress that had been made toward diversity, equity, inclusion, and belonging across the country. In Michigan, this had already taken place under the state constitution. So Michigan law schools that are public law schools have already had to navigate the restricted use of race in admissions, and now it's just spread across the country.
How does this perhaps impact, or even perhaps now further, for example, the University of Detroit's Mercy's mission to diversity, equity, and inclusion?
Well, certainly diversity, equity, inclusion, and belonging has been very central to Detroit Mercy, the university, to the law school, and really to the entire Detroit Mercy University. I'm very proud of that. I'm proud to be affiliated with the university that has stood up to support diversity in education. We're a Jesuit and Mercy institution, and both the Jesuits and the Sisters of Mercy support diversity in education. And so we're going to do what schools, the public schools in Michigan have had to do, what the schools in California have had to do, which is to just continue to uphold that value, to make sure that we are reaching out to students, even though the Supreme Court says you can't use race. And actually, Detroit Mercy was not using race in its admissions. But we'll have to reach out to make sure that we have a broad pipeline. We know that the law has not operated in a colorblind manner throughout US history. And a lot of what affirmative action was doing was to overcome that. And so we'll just have to still work on overcoming structural and institutional barriers that have stymied equity in educational pursuits.
Well, it's definitely a story we will continue to follow as we continue to watch the developments and actually the reaction all across the country and even here at home over this, in some ways, controversial Supreme Court ruling. Jelani Jackson-Exum, Dean of Law at University of Detroit Mercy School of Law. Thank you so much for your time. We appreciate it.
Thank you so much for having me. I appreciate it.